We're going to get started. Hope all of you had a very happy and safe Thanksgiving. What I am going to do is tell you that if you have any questions, just take yourself off of mute, since the chat room is going to be filled up with a lot of things other than your questions and stuff like that. So just do that if you need to. What we're going to do today is we are going to review from the buyer agent's perspective issues that have come up that you must make sure that you handle. And just to kind of reiterate some of the best practices that you should follow, I am going to tell you that from time to time things happen, and it's one of those situations where you have to kind of keep updated as far as what's going on in the best practice. Just remember to put yourself off on mute. If you have any questions, just take yourself off of mute. Okay? All right. So before we get started on all the various things that we're going to talk about for the buyer agent today, I'm going to give you an update from the TXR task force. We are looking at changing a lot of the Texas Realtors forms. We've even sent some recommendations back to TREC, Broker Laura Committee, regarding some of the contract. We have issues all the time that things, when changes have happened on certain forms, it has a domino effect, and sometimes TREC has caught that and made changes and other times not. Case in point, the amendment. If you had a buyer and they want to extend the termination option period, if you look at the amendment, it says that the buyer has paid seller. Well, what did we have on our original contract for how the buyer gets the option fee received? They pay it to the who? Title company. So very confusing things are going on. I really believe that agents have to do a lot more parts of our processing that should have been taken care of by some of the forms and those things. The biggest change that we're going to really see on the forms is related to some of the Department of Justice complaints against NAR. And the main thing, and we'll talk about the buyer tenant agreement in great detail, but we asked them to look at the language in both the listing agreements as well as our buyer tenant agreements, a provision that in the event we have an uncooperative client, that we have the ability to terminate. While you can reach mutual agreement to termination, the language that's in the agreements is not real clear, telling the seller that if they, or a buyer or a landlord or tenant, that if they become uncooperative, that we have the ability to terminate. And I don't know about you, but we do have some clients who become uncooperative from time to time on something like that. So, but I'll keep you posted as we progress forward with making a lot of the changes. Information about brokerage services, we're going to talk about the fundamentals of it. We're going to review the buyer tenant agreement, what you might need to add to the buyer tenant agreement from time to time, and then what forms you need to review with your buyers prior to an offer, and what questions you need to receive answers to from the listing agent. And then once you get an executed contract, what do you do on something like that? Now, the IABS is very basic. We all learned early on that by law, we are required to provide this information about brokerage services. It's not a contract with the prospect. It is complying with the law, but you must get them to initial and date it. If there's no exceptions, you would always have to prove that you did that. Otherwise, you could be in violation. So again, make sure that you do that at the right time and make sure that that is confirmed in writing. It's not a binding agreement. Nobody should be afraid to acknowledge it. It's really, we're complying with the law on something like that. And really, if you have somebody who won't initial and date it, I think you need to think very seriously about working with them. But here's what you'll need to do to prove that you did provide it at the right time. you would write on the form that you provided it to them and they refused to initial and date, and then give them a copy of it, and then keep that other copy forever and ever, okay, and notate who it was given to, but they refused to sign it. You just have to have some proof of delivery. And I've talked about all the TREC complaints that resulted in horrible violations for a buyer agent. In fact, there was a complaint that was done, and it didn't involve the buyer agent, but when TREC goes into a complaint process, they have the ability to ask for any and all documents that they want. And so just please make sure that you do this, that you are consistent, that you keep these records, and that you can prove that you actually deliver the information about brokerage services at the right time. Any questions? Okay. Well, why do we do a buyer-tenant agreement and we don't do it before we get paid? You would probably want to do this at the same time you do the information about brokerage services if you're going to work with them. But the reason we do this, for many reasons, but the primary one is that we abide with the code of ethics, and your broker has understood this. They are required to comply with them as well. And so what it says is that all agreements between all parties will be in writing. Okay. The biggest thing is that in your brokerage operation, if you had a buyer who wanted to look at one of your listings of the brokerage, you could not show them that listing until they had agreed in writing to allow the broker to become an intermediary. Otherwise, you're just opening the door for the listing agent. So what we're going to do now is we're going to look at the highlighted provisions that keep coming up that agents are having difficulty with on the buyer-tenant agreement. Okay, while every last one of these paragraphs is important, there's just a couple of things you just don't want to miss making sure you complete. I noticed email here, okay? And the reason for that is because if you don't have an email address for them, you cannot communicate by email with them. Okay, so just remember that's their permission to communicate with you by email. This is an exclusive right to act as the client's real estate agent for the purpose of acquiring property in the market area. Now, this is the first time you hear market area, but it's paragraph 3C. You will never leave this blank. And what I have found is the best boundary identifier are counties. You could do zip codes too. Those are both easily accessible as public records, so people would understand and know the boundaries. What's not acceptable here would be MLS codes, unless you attach the MLS code showing where the boundaries are for that code and that type of thing. What we have seen in market areas where we have an investor and they work all over the greater metropolitan area, but they have special agents in each one of the areas, right? And they do this because they limit the market area to maybe a zip code, could even be a subdivision, right? Could be, you know, a property address. It can be as narrow or as broad as you want. If you want it to be broad, you will use counties as the boundary identifier. Any questions? Okay, term, you're never going to leave blank. There's a beginning date on it and an ending date. And please don't get creative and say when they purchase a property as an ending date, something like that. You're just not going to, you're going to have dates. That makes it enforceable between the buyer and the client. Now, the broker says, look, I'm going to use my best efforts to assist you in acquiring a property, negotiating for you, and anything else that's in this agreement. The client says they're going to work exclusively through the broker in acquiring property in the market area. Now, that's why you don't leave market area blank, because that's what ties the client to exclusively working with you is the market area. They also tell the client that they have to inform other brokers, salespersons, sellers, and landlords with whom client may have contact that they are exclusively represented. What you would say to a buyer at this point is, for instance, You're not going to go on a website of another brokerage and click on a link and then somebody's going to contact you from them. You're not going to call the sign information. You're going to call me first, and then I will get the information that's needed for that. The problem we have as buyer's agents is many times when buyers are driving around or they see a sign that pops up new, say, they're going to call that sign, and the individual answering those calls is probably not the listing agent. What we have encountered is we have agents on a team of a listing agent. They contact and they convert those calls into a party that they're going to represent, hopefully. And so what happens is they fail to ask critical information of the prospect. Was a broker bringing this property to your attention? Are you under a signed buyer tenant agreement? All those things as listing agents we're required to ask. But those agents that answer these calls sometimes don't do that. And so it would cause a problem for the buyers, because the buyer would be set up to have to tell them what? I'm exclusively represented by every time. So that's why this paragraph, while there's no fill in the blank, there's a lot of explaining that you need to do along with this agreement.
Could you explain the market area and property again, please? I kind of missed that part. Thank you.
Yeah, you have to define the boundaries of where you're going to look for your search for properties. And the counties are the best boundary identifier. I notated a few others that might be used by individuals who want to narrow it down. They may want to narrow it to a zip code. They may want to narrow it down to a subdivision, those types of things. We're going to talk a little bit more about properties being brought to their attention when we get to the broker's fees on something like that. Does that answer your question about market area? Okay,
usually just put town counties. That's like the best way.
They're the best boundary, and they're very broad. So say, for instance, they're right on the boundary of Harris and Fort Bend. You know, if you just had Harris, it won't cover you, and you won't have to bring any properties other than what's in Harris County to their attention. Those types of things.
Okay, thank you.
Now, representation, there is one fill in the blank on this paragraph, and it's the name, any employer, relocation company, or other entity acquiring a property that they're going to use benefits. Here's what I'm going to tell you. If somebody is coming in and they're being relocated for a job, you want, as a buyer's agent, you really want to get clarity on this, because here's what happens. The employee is being relocated, and there's a provision that the company says you must abide by these terms in order to receive any benefits, right? But they're so anxious and they're so excited. They came in over the Thanksgiving week and they want to get a jump on this. You need to have your ears perked when they say they're being transferred in by a company or they're taking a new job with a new company. You need to find out these benefits. And the reason for that is we have too many buyer's agents that work so very hard, and then a week or so before closing, the buyer comes back and says, oh, I won't get these benefits unless you agree to give 45% to this relocation company. I don't know about you, but those are the kinds of things that don't feel very good. It's not that you wouldn't continue on with them once you found out that information, but you would need to know exactly what are the parameters of what is this relocation company expecting of you in order to represent the buyer. Any questions? Okay, paragraph 8, intermediary. Is this important? Yes, I mentioned it earlier.
Marilyn.
Yes.
I'm sorry, I'm slow at hitting that button. So if they are informed a week before closing that, oops, you got to pay 45% referral to the relocation realtor, and then you have to do the math and say, oh, and I got to pay 35% to my broker if you haven't capped, that math is going to get ugly. So they need to ask that question as early on as possible, because they may end up working for 10%.
Oh, I agree. And we have had, I'll be honest, we've had this happen over and over and over again. And a few times, and this has been exceptional times, and this has usually happened on the listing side, not so much the buyer side, right? But we've even had where, because the buyer failed to disclose this and they were going to lose their benefits, the company had negotiated with the buyer agent. That's typically not the case. Not every relocation company is open to that. We have had some issues on listing side because the sellers as employees went to bat for us and fought for us. But buyers are not in that position. Buyers are going to lose a lot of money. And so they have a different frame of reference. And our problem is, I'll be honest, we abide by the code of ethics. Are we always going to err on the side of what's in the best interest of our client? Absolutely. But you need to make a conscious decision about it. Some relocation companies make you write reports every week, that you have to do certain things for them, for this employee. So it's really an agent wanting to take on that extra layer of responsibility that they might have with it. But yeah, you need to know these things really before you get to the signed agreement. But because they're stated in writing in our agreement, it's best that you make sure you have covered all of that, not leave it blank, because a blank means you didn't ever cover that. Okay.
So Marilyn, in this case, do we contact the listing agent or the company itself to find out the?
Your buyer better know. The listing agent won't know. We're talking about a buyer agent representing a buyer. So you need to find out from your buyer. They're the only ones who would know.
Okay, thank you.
Mm-hmm. Now, intermediary, does it have to be marked? Oh, it does. Because in the event they say no intermediary status, which is B, that means you can never show them a property listed by the same brokerage. Okay. And that could cut out a lot of properties for them. When you mark A, the broker now is going to have become an intermediary. They have been provided information by the buyer to become an intermediary, the same way that the seller has allowed the broker to become an intermediary. And then what the broker does is they make appointments so that the listing agent will represent the owner, buyer agent represents the prospect, and you're able to go forward once that's done in writing with negotiating on the contract. So just remember, this paragraph is very important, and one or A or B has to be marked, and if B is marked, you can never show your brokerage the listing. Now, paragraph 9 rather, competing clients. What does a competing client mean? Well, it means that the broker may have 10 agents with exclusive agreements with their buyers, and they're all interested in the same property. Could that happen? Oh yeah, and it does. We don't usually understand competing clients unless it's brought down on our personal level. So let me explain what you would have to do. This is a warning to the client that says the broker may represent other prospects that are all interested in the same market area and the same property, right? Now, if it happens to you, you're working with 3 buyers, and they're all interested in the same subdivision, and you know this because you've worked with them before and you're working with them, and something comes up and now it's an available property and it meets the criteria of all 3 of these buyers that you have under buyer-tenant agreement, right? Well, what happens on competing clients is you have to go to the first party that you had under a buyer-tenant agreement. You're going to go to them and you're going to say, you know, we reviewed the competing clients, but now I've got to tell you it's down to my level. I'm representing other buyers that are interested in the same property. So I come to you first because you're the first one that I've worked with. How do you want me to proceed? Do you want me to solely represent you in this property? And I will appoint other agents to represent those other buyers of mine for this specific property only. So you're going to defer to the first party. They have preference. They get to tell you how they want to work. I'm going to tell you my experience on this. And I only get this because the agents contact me later and tell me the rest of the story. But when we've had competing clients and the agent has had competing clients, and the first one says, I want you to represent me only, and then they appoint another agent just for this property to represent these buyers, no buyer has received the property. It's almost like Murphy's Law comes into play. None of them won the bid for the contract. But we have to do this. We've had some buyers who have said, oh, that's okay. I'll let you do me and the other buyer, and then you just tell me everything that that buyer is submitting so I have a better offer. Can you do that? No, I don't think so. So again, you know, we've had all sorts of things dished at us when we represent buyers that are all interested in the same property. And it's not easy to navigate, but you will go to the first party and let them know that. I am going to tell you what happened on a situation, and this is the agent who stands very tall in our industry. They had a similar situation. They appointed another agent for this transaction only to work on that property while the other buyer agent took care of their first buyer. Well, both buyers didn't get the property, right? So the second buyer was going to come back to the first buyer agent, right? But what happened was they liked the second buyer agent that was appointed by the first buyer agent better. And that agent told me that they had no problem with it. None. It's whatever the client wants, that's what we'll do. I will be glad to turn over my client to this other agent. You can't ask for a better agent to be in your operation and to work at such a high level like that. We just don't see that typically happening, but sometimes that's what it will happen. The confidential information, again, we don't share any confidential information, even after it terminates. Case in point, you're a buyer agent and your buyer terminated during the termination option. And it's up there in MLS on the archive, it tells them. And a new buyer agent whose buyer is interested in the property contacts you and says, why did the buyer terminate? Can you disclose that information? No. No. So again, be very careful that you're not going to disclose anything that happened in this transaction, even as harmless as it may seem that you get that call from that other buyer agent. Just please remember that. Now, broker's fees. Okay. I don't know why, but agents have a problem with this paragraph, and especially explaining it. Most buyers tend to read this because they want to know, what am I going to owe any money? That's typically what a buyer would read this paragraph for, no other reason. Paragraph A is basically saying that we're entitled to a compensation, that the broker is entitled to a fee, right? And gives whatever fee it is there. Now, paragraph B tells the buyer or tenant, this is the source of the payment. We're going to first seek to get the compensation from the other party. Oh, is this kind of important to tell the buyer at this time? Don't go to open houses. Don't call sign calls. Don't click on websites that might link you into another agent. Don't go to a new home builder without me. All these things will happen if this buyer does that, and you are not procuring costs and due compensation from the seller or landlord or the builder. Okay, so be very careful about making sure you explain it. What I did highlight says if such persons refuse or fail to pay broker the amount specified in 11A, then the client will pay them. See, that's where that buyer gets upset. They read this and they don't want to pay you at all, right? So what happens if you cross out this sentence in the paragraph, that means you can never go back against them if they did go to a builder without you and you're not on the contract. If they did go to the listing agent and you're not on the contract. So just remember that if you mark it out, you can't make it enforceable. In other words, it no longer exists. Okay, that's why you want to reference it very clearly with them. Now, here's what I'm going to tell you also. You know how we filled in market area and say we said all the properties in the market area. Do you think that includes properties that do not offer compensation to the buyer agent broker?
Yes.
Yeah. See, that was what NAR and the Department of Justice, they were all over the settlement agreement that they would not abide by this year. They decided they're not going to accept it. Part of it was because buyer's agents in their script were saying that their services were free, and you can't do that. That's a violation because your services aren't free. Okay. And the buyer thinks they're paying them because they're giving the seller what they want, right? Sellers think they're paying it because that's the cost they had to pay in order to get this cooperation. So again, be very careful about understanding totally what market area means. And if the buyer says to you, I want you to mark this out, you're going to say, well, are you, so in other words, you are agreeing now not to go directly to any other listing agent, to a builder directly without me, that you're going to abide by the terms. I will agree to mark this paragraph, that sentence out of that paragraph, but you must agree to do that. And you can kind of reinforce that in special provisions, and we'll talk about that in a minute. Any questions?
Yes, Marilyn. So
Mhm.
does that mean that if they want us to mark this out, is to show them properties that only the listing agent or the seller agrees to pay the commission?
No, that we're going to talk about that specifically in the other thing. But here, what I mean by this is, say, for instance, it's in MLS, right? And your buyer went directly to the listing agent because of a sign, right? And they cut you out by accident. You won't be, if you break and take this sentence out of the agreement by striking it through, it means that you're not doing any compensation. You're going to let the buyer get away with that. What we're also going to talk about in special provisions would be they're agreeing to only use you first and all these different things. Sometimes we need clarity with what these things mean because the buyers are not familiar with it. They don't read it. And sometimes buyer's agents do not actually explain the document to the buyers in total. But if you mark out the second sentence in paragraph 11B and the buyer went directly to the listing broker and their procuring costs, you're not going to be able to get compensation from the buyer.
So just always leave it there, pretty much. For you to
Well, you can, as long as the buyers understand and agree in writing. And that's why we'll get to special provisions that will be a little clearer on something like this. Again, it's not, if you mark it out, you're never going to be able to collect. That's just kind of plain and simple on something like that. Now, earned and payable. When is your commission earned? The broker's commission is earned when they actually enter into a binding contract to purchase or a lease property. Okay. And so it's not payable until it closes or if the client breaches this agreement. Again, we don't like to have to fight a buyer on something like this. We don't mind fighting the other broker if they've done something wrong and have interfered in our signed buyer tenant agreement. But it's very difficult unless you've got ironclad documentation that the buyer did breach the agreement, and they even actually state that they did that and why they did it. Now, in paragraph F, let me give you a situation that has caused some issues. You've got a buyer and they're looking for what? They're looking to build a custom home and they want you to find what? A lot for them so that they can build on it. Okay. In this paragraph, if that's the situation you're going to be involved in this with this buyer, you're going to include whatever fee you want to receive if the client uses you to procure and negotiate the construction of improvements to the property or what they might, acquire from a builder or a contractor at the time. And so again, This basically is telling the buyer, look, if I'm the one that's procuring cause and setting you up and introducing you to this builder, that I'm receiving a compensation. Just make sure, since this is a buyer-tenant agreement, the buyer will know that now they're going to have to pay compensation. But the builder, you'll want to secure a registration agreement between broker and owner, and that way you're going to register the prospect and the builder has agreed to pay your compensation. Okay, the buyer just needs to know you're going to try and collect a fee. Any other questions?
So that's all for new new construction homes, right?
Correct.
What do you mean
But-
the buyer would have to pay? Because I know we just have to create a relationship with the new home builders.
Well, at this point in time, it's saying that I'm either going to receive the compensation, the broker's going to receive the compensation from you, the client, or the contractors, and we put a specified amount. When you do the registration agreement between broker and owner, and you're with the registering these prospects with the builder, that means the builder will pay the compensation. But the client has to know we're going to try and collect a fee.
Okay.
And what the fee is equal to.
Marilyn, I have a question regarding the fee, but every builder gives different percentage. So how do we know what percentage to put under, 11F construction?
You can put what you normally would consider receiving of compensation in MLS. You could put that. What you negotiate is always up to you and the builder.
And do we have to disclose to them how much we're getting paid once we sign the agreement with the builder, broker, and builder?
I would think if they ask you, you would respond truthfully, yes.
Correct. But if they don't ask,
right here, we already told them.
got it. But my question to you is because well, I had this happen to me. The builder called me, said, hey, your clients are asking me about the commission. And do you want me to disclose it? I said, go ahead. I've already explained to them verbally that I will be getting 2% commission from you. But he said most agents usually don't want me to disclose that. That's why I'm asking you. But I would definitely disclose it. But
nothing's in writing. It's covered here in the buyer-tenant agreement. And based on the code of ethics, we would never hide that critical material information from our client. Just
Marilyn?
make sure you don't just do it in verbally. Yes.
Would this paragraph F1 also apply if the property is already built and still considered a new construction because it hasn't been lived in?
That's usually covered in the compensation here in paragraph 11B. The source would be from the seller, landlord, or their agents.
Got it. Thank you.
And the reason I bring this one up is just like Emily mentioned, we have a lot of situations where our agents are the procuring cause for the builder that these buyers will choose to work with. And we've had too many issues going on. Buyers get very upset. Builders, the one that Emily talked about, was very accommodating. Most builders could care less unless they feel they don't need a realtor ever to bring a buyer. And they usually tell the buyer, oh yeah, I'm just going to pile the commission right on top of what I'm charging you to build the property.
Marilyn,
Mm-hmm.
I'm still confused. So if I'm working with a buyer and we go to a new construction builder and the house has been started and my buyer representation agreement under this construction actually says none, but in the paragraph above, it says that I will get whatever commission I'm charging. Do I need to put on here, since the house was already started and they have gone under contract, should that have been my commission?
No.
Confused.
No, this is in addition to what's in paragraph 11.
That's what I thought. Okay, then I've got it right. Thank you.
Yeah, this is just in the instance where you have a buyer who wants you to find a lot. And then, then they want to find a builder to build on the lot, those types of things.
That's what I thought. I just wanted to make sure. Thank you so much.
You're welcome. Okay, protection period. Well, I don't want to be the bearer of bad news, but the protection period is really designed, and it survives the termination of the agreement, that the buyer has not gone behind your back and gone directly to the seller or the builder. You know, in other words, they're trying to cut you out of it. Because the protection period only survives if the client has not gone and is under a buyer representation agreement with another broker who is a member of Texas Realtors. And very similar to the listing agreement. These protection periods were done to protect you and the brokerage in the event that this client terminated solely so that they could go behind your back and that type of thing. So again, unfortunately, we looked at the language in the protection period quite long, as well as the default that we will talk about in a minute in our task force meeting. And there are lots of issues that come up on this, and we were looking at trying to make the language a little clearer so that the parties would understand what they were obligated to. Don't ever leave the county blank. I've had this a couple of times.
Excuse me, Marilyn.
Mhm.
Can I write the protection period for same as the contract date? Let's say if it's a half-year contract, 180 days, can I write 180 days protection?
You can, but you're not protected if this agreement terminates and they have another buyer tenant agreement with another realtor.
So if it's active, then I can put 180 days except it's terminated, right?
You can put 180 days. You would have to give it in writing so that they know what properties you're going to try and protect. The problem is if that buyer is free to enter into another buyer tenant agreement with another broker, and that broker is the reason that they acquired that property, you will not be protected.
Marilyn,
Yes.
there was a real estate company here in Houston that had a protection period for a year. And they sued the buyer because they checked the tax roll and saw that the buyer had bought a house during that protection period, quote, protection period. And they lost on that lawsuit because they didn't show that buyer but about 3 or 4 houses. And so what they were trying to sue and get paid for, it got kicked out of court because that protection period was no good because the agent hadn't done any work.
Right. Well, and the courts decide these things, and that brokerage actually sat on new construction homes. And in order for that prospect to get in to see that model home, they actually had to sign this agreement. That was the only time they never really performed any fiduciary duty. So it was a horrible situation. That broker had sued multiple buyers for that same type of thing. So yeah, no. You're either a fiduciary or you're not, just because you sign at one time, and you have to prove that there was an interruption and it was caused by the other broker, not you for not being responsive and following up with the buyers and that type of thing. Okay.
So is there like a certain protection period date that we should follow, or does it relate to whatever the date that me and the buyer agree to terminate the contract?
The protection period is based upon what the buyers and you agree to, or the tenants and you agree to.
Okay, thank you.
As I said, it's very rare that it's enforceable unless the buyer or tenant purposely got rid of you and the broker so that they could go behind your back to the seller or the landlord. That's the only way you'll be protected, and having provided them in writing all the properties that you call to their attention that you would want to be protected from. Paragraph 13. Remember I talked about the task force. We're looking at better language. I don't know, have any of you ever had uncooperative clients? unfortunately, if you've been in real estate long enough, you have. And it talks about if either party fails to comply with the agreement. But what we have wanting clarity on is when we actually get an uncooperative, that type of scenario. While it has here if they make false representations, but we've had clients who've actually become very belligerent and profane language is used. They are terrifying the agent and making threats and those types of things. And so those were the things that we kind of talked about in our task force, and the attorneys are looking at better language so that it's much clearer that it goes beyond this agreement or false representation on something like that. The addenda that we have is marked, and they always mark information about broker services. Wonder why? Well, it's because it's required, okay. But there are other items you can mark, and you can also add your buyer presentation about how you work or whatever you want to provide. You could also provide information about their wants and their needs and those types of things. That can all become a part of the buyer-tenant agreement, not just a document that you've given. You can also attach those. In special provisions, when we go back to paragraph 11B about the source of the payment, you could say that buyer agrees not to contact any listing agent signed directly, click on any website links for special properties, going to builders without first contacting me. In other words, that affirms the ability that you told them, I'll mark out that second sentence in paragraph 11B, but only because you agree not to do these things, right? You see how that kind of helps balance that? The other thing you're going to mark in here is that, and what I've seen where buyers are told, okay, now there could be other properties that are in our market area that you would want to meet your criteria, right? But their brokerage will not pay my compensation, my broker's commission. Are you willing for me to show you those properties and then you would pay the compensation? And based upon their response, you're either going to say that buyer will determine on a case-by-case basis, right? And you're not going to go forward with anything until you amend the buyer-tenant agreement that they now will pay your compensation because the other brokerage won't. Or they're going to say, do not show me any properties that are not listed in MLS or where a builder will pay the commission. Okay, something simple like that, but it makes it very clear that we are actually abiding by all the criticism and complaints that have come in to NAR regarding our excluding properties that might match our clients' criteria. Our documents are pretty good in the state of Texas, I must admit, because when I looked at other states, that's why there were issues with the Department of Justice feeling that NAR and all these different issues were going on about MLS and cooperation. And so it's the buyer's choice, but the buyer has to know you're not a nonprofit. Your broker is going to expect compensation. We're first going to try and collect it from those that give a unilateral offer through MLS, or more importantly, where the buyers will say, I'm willing to see those properties and I'll pay your compensation. One or the other, however you want to do it. Now, paragraph 18 is additional notices, and the one I'm going to tell you that you probably need to pay attention to is F. When viewing a property, right, client might be recorded or otherwise monitored without client's knowledge or consent. Is that possible? You better know it 1000% today. Okay, that's how it's done. Additionally, you as a buyer's agent or a buyer, you can't take any pictures of the property without written permission. And that's the owner's consent, not the listing agent, but the owner's consent on something like that. A lot of times we've taken it, you know, the listing agent, bless their hearts, they are so accommodating. They'll say to the buyer agent, not in writing, but they'll say to them over, don't worry about it, go ahead and do that. Then the listing agent overstepped their boundaries. And the seller got very upset because that very afternoon, that buyer agent posted something on the Facebook page. No, you can't do that, folks. Everybody understand? And I just don't want you to get into serious trouble as you would, or your buyer or your tenant. Okay.
Marilyn,
Uh-huh.
can I ask you a question on that? Because in our showing service, we can actually request to do a virtual tour when we don't have the buyer with us. Do we need to get additional information from the seller?
No, if it's there and you're acquiring and the showing service is doing their job and getting that acknowledgement from the listing agent or seller permission, or the seller's already granted that permission, that's fine. But again, we have too many agents that are doing it without getting permission and without even informing the showing service that they're going to do something.
Okay, and then the last question I have is, I think it was last month or month before last, you mentioned that if we have a buyer's representation with two people, husband and wife or couple, and then they bring their mother-in-law or father-in-law with them, is there a form that we need to get that individual to sign?
Well, you would have them you would do an amendment to the list, to the buyer tenant agreement, adding them.
Okay.
And then attaching all the documents that the other buyers had signed.
But what if they show up when I'm showing and I didn't know they were coming? How do I handle?
Oh, you're talking about showing. You're going to have to say, I really, please don't take offense at this, but the seller has to know all parties that I am bringing onto the property. Let me get permission to have you accompany with it.
Okay, great.
And I'm going to tell you, I talk about this in jest, but I had a minivan, and it seemed like it was a magnet for all the buyers I would show property to bring all their extended family along. It was like a party van to them, right? And so what you don't ever want to do is have anybody other than your clients on a showing. Now they can have their children with them, but boy, they better have those kids like Velcro attached to themselves, right? But we've had too many issues go on, and even during the training that we did, the broker mandatory training last month, Michael popped in regarding a situation that we had in our brokerage on something, and it was so innocent. You're not thinking anything bad is going to happen about it, and then those things happen.
Okay, that's what I remember that from last month. Thank you.
Yeah. Okay. So now we come to the part where everybody's going to sign, right? The broker's printed name is the brokerage. It's intermittently used in all of our forms. Always use their brokerage name as the license number, and then you're going to sign it, and then your clients are going to sign it date. And as I said, this agreement is one of those things where we don't usually go through them in detail, but every once in a while, those situations will come up where it will take us back to that document. We may have to amend it because something has changed. Now the buyer says they do want to see properties where the compensation will not be paid by the seller or the landlord or the agents, listing agents. So again, just remember it can be modified from time to time. And that's what we're going to talk about now. What do you need to add to it? You know how I mentioned their wants and their needs? I don't know about you, but sometimes we have auditory learners. They hear things and they process it, right? Some of us are visual learners. We have to see it in order to process it. And I think I remember every time I would take all of their wants and their needs and set it up that way for them and had it in writing, they looked at it and they had a very different response than what we had when we were all talking about it. So that's not a bad thing to do it. I did have an agent last week who called me and wanted to fire the buyer because the buyer was changing their wants and needs too much. And they said that they'd had it with them. And it was kind of funny because that can happen, right? And so she'd been showing them since July, and it was over and over. They were changing their wants and needs. She just had it. That was like the last straw for them. There's nothing wrong with that as well. Just always make it about you. You're the reason that you're releasing them to work with another brokerage. Don't ever point to them as because you keep changing your mind every day. You're driving me crazy kind of thing. You may think that, but please don't say that. Again, you can add that as an addenda to your buyer tenant agreement, and you're good to go. Again, as I said, seeing things in writing sometimes brings into focus, is this really a want, or can we move that more to a need, or can we move that need to a want, those types of things. Your presentation that you provide to them. I've seen several of the agents will share them with me and ask me to review them. And I love it because they talk about the process they work by. And it's a great guide for the buyers. The buyers have to understand that there's a process associated with representation and what the normal processes that this agent will use and how they will work and those type of things. Sometimes there are multiple team members that might work in benefit of the buyers, and the buyer agent will have them from time to time assist them. There's nothing wrong with that. The other thing is, I'll tell you, we had a TREC complaint on one where the buyers actually filed the TREC complaint, and they wanted to, because they wanted to fire the buyer agent because they said the buyer agent was not procuring cause and wasn't assisting them. You know how these buyers are, right? Well, TREC came back, and the only thing TREC really found fault with the buyer agent was that they failed to put in writing their response time, how they worked in their response time. And the reason for that is these buyers typically did this to the agent. The agent's out working, right? They call and say, we want to go see this builder's home right now. We're out in front. That kind of thing. And TREC felt that the buyer agent was a little abrupt in the handling of those situations, and maybe was not acting in their fiduciary duty at the potential they should have been. And so they advised that that should be done in writing on something like that. So again, that's if you have a timetable, say you're not going to ever be available on Saturdays to show property or Sundays, you know what I'm telling you. And again, that same timetable doesn't affect you once you're under contract. You are bound to respond timely once a party is under contract. But just so that there's clarity on how you'll take care of them in the course of procuring that property for them. And what forms now do you need to review with the buyers prior to offer? Well, the tax records are a starting point. Besides all the other information you're going to get from MLS, you're going to look at the tax record. You're going to circle the square footage. You're going to circle maybe the tax jurisdictions on it, you know, all pertinent information. The reason I say circle square footage is because our contracts are not about square footage. They're about value. And unfortunately, a lot of buyers agents don't actually review that with buyers before they make their offer on a property. The other thing is we have had situations where if you tell a party something, they're thinking it comes from you. You don't want to go that route unless you have proof or a public record showing this is where your source is always from another source. So you want to make sure that they understand that these values like the square footage, your build, other things is really coming from another source, not you. I've done this a few months ago. I went through they updated the general information and notice to buyers and sellers last April to put in there about values, appraisals, and stuff like that about But we're going to probably change this form again in light of some of the things that have come down from the Department of Justice and that. But when you are working with buyers and they're telling you all these things, all of a sudden you're going to look at that document and say which paragraphs might apply to this buyer in their situation. And then you can highlight those with them and bring it to their attention. All the paragraphs are great and they each talk about everything. And actually, this is a document that can be used in every kind of transaction. Doesn't mean just if they're buying an improved property, we're talking about unimproved property as well. So again, remember to kind of think about doing that. Now, here are some of the questions that you need answered by buyers prior to an offer. And the reason it's bringing a little more clarity into where will the time limits maybe come into play on this, or what things need to be considered. And the big thing is, of course, you always need to find out, does your buyer have a property to sell in order to purchase this property? Okay, that's important because we have an addendum for sale of other property by buyer that buyers may want to add to their offer. The other thing is, we have this from time to time, and this is a lot really for newer agents who may not have been faced with this, but we asked the buyer, are you going through a divorce? And the reason for that is we've had lots of buyers who were not finally divorced that actually went under contract, and the soon-to-be ex found out about it and caused a major problem, right? So again, it's real important that you understand the status. We've even had buyers who said they were divorced and they weren't. I mean, I don't know about you, but I think I would know. That would be either a day of great comfort and joy or great sorrow. And that would be something you would know as if it was happening to you. The other thing is the buyer currently under a lease in an apartment or house, and they would have to give notice to a landlord for early termination or termination in order to close on this property. I don't want you to put yourself in the middle of that lease, but I do want you to put yourself squarely in writing saying, have you, done this early termination in writing with the landlord? See, the key is in writing, because what we had happen was the tenant said, yeah, I talked to the landlord, everything's cool, right? Agent thought nothing of that. They're not a part of the lease, are they? Turns out the buyer is getting ready to close, and the lenders found out about this lease, and the landlord will not release them, and the buyer was no longer individually approved for the mortgage and the remainder of the lease. Okay, so don't get caught in that situation. Don't interfere in their lease, but just confirm you have done this in writing, correct? That's all you have to do. You don't give them a form, and you don't give them any other advice on something like that.
How would we handle number 1 again, please? When if a buyer has a house to sell?
Yeah, well, then that means that in the offer, they're going to attach the addendum for sale of other property by buyer. We have a special addendum for that.
Okay.
Marilyn,
Uh-huh.
on a couple of the leases that I've done lately, the property management company had in the lease information about early termination and how to go about doing that. Would that be sufficient? Since
No.
that's, okay, I need to get more information from them. Okay.
Because while they have that at the time of lease,
Mhm.
giving notice is what the tenant is required to do, and getting that notice affirmed in writing.
Okay, great. Thank you.
Number 4, will your buyer be allowed to grant the seller a temporary residential lease on the contract, temporary lease? Well, why do I mention that? Well, for 2 reasons. Sellers usually find that this is the best time to negotiate, right? At time of offer, rather than come back in an amendment and try and get the buyer to agree to it. But the problem for the buyer is that their lender, if there's a loan financing on it, the lender is the ultimate source. They're going to tell the buyer, yes, you can, but for no longer than this amount of time. So you have to know that they can do it and how long. Okay, those would be 2 key components for a buyer agent to know in the event that the seller comes back and says, I like your offer, but I need a temporary lease, that kind of thing. You would have to have that from the lender, that information.
Marilyn,
Uh-huh.
I ran into this last year as well. And turns out my buyer had to also get permission from their homeowner's insurance for granting a temporary lease back.
Oh, yeah, no, any buyer who's going to have a tenant in the property has to tell their homeowner's insurance, period.
Right.
Yeah,
And that was, so it wasn't just the lender that had to give permission, it was the homeowners had to give permission for up to a number of days.
mhm, absolutely.
So we did it both. Okay.
Mhm, absolutely. Um, and hopefully buyers understand that when they get their homeowner's quote, they have to tell the insurance agent everything. Otherwise, they're going to be in trouble on something like that. We don't do that for the buyer does that. So just make sure you let the buyers understand that they would need to let the homeowners, whomever is doing their homeowner's policy, know what's really the terms of the contract that's been accepted. The only problem for a buyer too is sometimes, yes, you have a question?
I was going to say, the one thing I'm saying is more for newer agents is that a lot of times when you're doing this part of the contract, the seller is still in the mindset that this is their property and they think they can negotiate the rent amount. And so you have to make sure, as these newer agents who are doing this know, the transition to the transaction has changed. Is now that the buyer becomes the landlord, they tell the seller how much they're paying rent, not the other way around, because newer agents can be hoodwinked into thinking that the seller can say how much they're going to pay for rent.
Yeah, and I reviewed that in detail and provided forms that buyers would sign and sellers would sign. So they have that in their library file. If you're going to have that situation and you're not familiar with it as an agent, you want to absolutely get clarity on something like that because it can cause a great deal of problems. The other problem is the sellers notify the buyer agent. Listing agent says, oh, the sellers don't need the temporary lease. They've gotten everything taken care of. And the buyers have jumped through hoops accommodating a tenant after it closes in funds. And the buyer says, no, I'm not going to remove it from the contract. They have every right not to remove it. Okay, so just don't be shoved by the listing agent saying, well, you have to remove it. No, they don't. Actually, once the parties sign a contract, until they both mutually agree to the amendments, that contract stands as written, period. So I know we have a lot of agents on the other side that tend to be a little forceful on these things, trying to tell agents that they know may not have as much experience that you have to do this, and that is not the case. Just listen to what they say. Don't have conflict because that only hurts your client. Then get with your client and review all of this. This is what they told me, and this is what they're saying, but really it's, you have options here, and then give your client the options that they have.
And this is for the lease back, right?
Uh-huh.
Okay. And you talked about the library forms. Where is that?
The Market Center has all of my PowerPoints, my videos and training. And so I don't know exactly where they have it. Somebody who's on the call may be able to let you know that, but they're all there. And the forms that I provided should be available to you as well. Okay, so we went through the scenarios, the biggest issues that typically come up when a buyer has certain situations, but now we need certain pieces of information so that we can put this offer together for our buyer properly. And you need to do this in an email. That way you can affirm to your buyer, look, I did send them the email. Maybe they didn't respond, and I'll tell you about how to do that in just a minute. Is the property subject to a residential lease, a fixture lease, whatever, because now we have new addenda that need to be attached to the contract offer at time. And if there's a fixture lease, there's even more information that's needed before your buyer is going to make a determination what they want to negotiate with the seller. And basically doesn't mean, can it be assumed? What are the requirements for an assumption, and what are the costs involved in these types of things? Again, it has caused issues sometimes when the buyer thinks that they can just assume something. Just make sure that it's okay with the lender on that type of thing if the buyer is financing. Are there any exclusions of real property that will not convey? This is one thing that I wish we had more good listing agents who placed the exclusions, so that a buyer would know and a buyer agent would have them when they're showing the property. That way the buyer's not going to get attached to it, or sometimes it means the buyer absolutely wants it. You know, you just never know. But you will need to know ahead of time, because that's in paragraph 2 of the offer in the contract form. You need to know that. The other one, are the sellers subject to the first? Now this you're going to do each and every time, and the reason for that, in our contracts, it says very clearly that if the person is a non-foreign status, okay, which most of our sellers are non-foreign status, they actually have to provide an affidavit affirming that they are not a foreign person. Now that's in our contract, and 99% of the time that is never done. We don't have a title company who wants to assist with that. But if the only areas where we've had issues is when there is a foreign person. I'm not saying that the contract is not clear. The contract is very clear. If that seller doesn't provide that they're a non-foreign status affidavit, the buyer has to withhold the IRS regulations. That's crazy. But that's a whole different matter on FERPA. But again, ask it each and every time. I don't care what the person's last name is for those sellers, that has no bearing on it. Each and every time you're going to do that, because your buyer has to make a decision. Do they want to be placed in a situation where they're going to have to complete forms, not you? Title companies that assist with helping the buyer file the IRS required forms, they would be a good source for the buyer to find out, what is it that I need to do as a buyer, collecting all this money from the sellers and then reporting it to the IRS. That is not something we do, okay? But you do need to know the answer to that. And it should be an agent remarks that they're a good listing agent. It's not in the seller's disclosure because it's not about the property, it's about the seller individually. The other thing is, do the sellers have any smart devices? Because now in paragraph 10, the sellers have to give all the access and codes and everything controls to the buyer before it funds. So you'd kind of want to know if the buyer is supposed to receive it, right? You would need to know that type of thing. And so would the buyer need to know that. The other thing is, just remember that if you have got a property that is subject to an addendum regarding residential leases, okay? And this is only typically where the buyer is a landlord and they're going to place this property in their portfolio. Buyers who have to occupy the property as their residence, this is not going to work for them. Again, the lender is very clear on these types of things with your buyer. The problem is if the buyer happens to be a landlord who's going to add this to their portfolio, as a buyer's agent, you're going to have to periodically visit with the listing agent in writing regarding paragraph 3B of the addendum. Is that still true? In other words, the landlord is required to be truthful about the statements that they made about the tenants are current and there's no issues with any tenant that's currently in the property. And the last thing is, I have given you buyer's checklist to follow and lender worksheets and those kind of things. And they kind of help you understand the process a little bit more. And plus it really tells the buyer what they need to know and what to expect in the process as well. Now, you have an yes?
All of the paperwork that you said that we could look back at to follow, where could I find that?
That should all be in .loop.
.loop, okay.
Should be in the templates, in various KW forms and those types of things. Now you have an executed contract. What do you do? Well, we're going to go into more detail next year about that in January. But for right now, The moment you receive notification that your client has received an executed contract, you're going to verify some things. Make sure that the executed date is correct. Only the brokers, the agents, place that executed date, and that executed date is when the buyers have received notice of acceptance of offer. Okay, so if the listing agent sent it over at 11:30 p.m. at night and you actually were like normal people resting at that time, and so was your buyer, then the next morning when you looked at your emails and saw that, and you saw that they executed it the night before, you would correct that and send it back to the listing agent saying, no, actually the buyer just got notice this morning, so the executed date is today. That is what your job is to do. Don't leave it for a week. For goodness sakes, do it at the time you receive it. Don't let it go any longer than that. If your buyer's financing, make sure you deliver an executed contract to the lender immediately. We've had some buyer's agents who didn't know to do that. Buyers didn't do it. And the lender came back and said, I just received the executed contract and we're 20 days into it. A big mistake. Okay. And buyers are expecting us to know all these processes. Again, the time limits that I've given you are based off the executed date of the contract. So if you don't have one, what are you going to do? You're going to have one on it to make sure when you've gotten acceptance of an offer. Any questions? Well, you know, buyers are an intense scenario. In other words, I'm not saying the buyers are intense, although they can be many times too, but it makes the buyer's agent very much in that transaction, and sometimes on a daily basis, because things are needing to be done very timely on this. And my advice to you, just as it has always been, is anything that your client says to you, say, the biggest issue that I know is that we have buyer's agents who find out that the buyers want this, this, and this during the termination option. And so they're trying to prepare the listing agent for it, and they send it over. Will your seller consider these repairs? No, that's not how this works, folks. You're a fiduciary. You go to your buyer, have everything in writing on the amendment to the contract, what your buyer wants the seller to acknowledge, accept, or review based upon that. You would have to do that to fulfill your fiduciary duty to the buyer. And once that's done, many times buyer's agents think, oh, I sent it over before 5 o'clock on the last day of the termination option. Does that count? No. Again, until the parties fully execute that amendment before 5 o'clock, your buyer doesn't have anything. They've just lost the unrestricted right to terminate. And truthfully, there are a lot of sellers out there that feel, well, if you're not going to terminate based upon this, I'm just not going to agree to any of it. You know, that you just don't know what a seller will do. But as a buyer's agent, you never want to miss performing your fiduciary duty first for your buyer. I know you are cooperative with the other broker, but your first interest is always to your buyers. Okay. And we've had a lot of buyer's agents that have done things by emails, but not with an amendment. And that's not in your buyer's best interest on something like that. Any questions?
And you said this is when your client wanted to change something that they're looking for?
Well, in the termination option, when the buyer has done their inspections, the buyer may determine, I want the seller to do this, this, and this. Well, you're going to do it on an amendment to the contract. You're not going to do it verbally. You're not going to do it by email. You're going to do it on the form where the buyer will sign it. It's very clear what they're trying to negotiate with the seller. Okay, does anybody want to know what we're going to do next month? Of course you do.
Of course we do.
Yes.
Well, because the law has changed as of January 1st, 2022, regarding leases, what landlords are required to do. We're going to go through that portion of it. I'm really concerned for lease listing agents, because if you have a property right now that is, you're going to list it for lease, say in the middle of December, and say there isn't a tenant by January 1, your landlord would need to comply with the law on something like this. And so I'm going to show you in the model tenant criteria how to change that. Make sure your landlords incorporate that. And we're also going to visit a little bit more with the fair housing issues and about assistance animals that still comes up all the time, and various things, just so that you're kind of prepared for what happens January 1. But more importantly, in today's environment, you don't get to do leases for a landlord or a tenant unless you absolutely know the fair housing, period. You just don't. And so I'm not going to say that the lease is not going to change. It did not change because Texas Realtors creates this form. It did not change with that provision in the lease where a landlord and tenant would acknowledge about, had the property flooded or is it in a 100-year flood zone. So we're looking at maybe some changes on that as well. So, but we'll visit next month about leases in preparation for the deadline of January 1st. All right, good people, y'all take care, and I'll see you next month. Bye.
Miss Marilyn,
Yes.
do you know anything regarding apartments leasing?
I know that all we do is get a referral and an invoice for apartment leasing. We don't advise the buyer at all. Apartment leases are not a part of our library. But you certainly can do it, but I would secure the compensation from the apartment before the tenant signs that lease.
Okay.
And
So
it's usually, we consider it a referral fee.
Okay.
Miss Marilyn, I have a question.
Okay.
Yes, I have had a situation this month with a couple of different agents who refused to give me a tenant criteria in writing. So they just said, nice credit or very vague description. And they refused to give me the tenant criteria in writing. And in fact, I submitted an application without it. And I'm still waiting. It's past maybe 3 weeks since we applied. So still
The landlord's required to respond within 7 days. The thing for your tenants is if the landlord hasn't provided their criteria in writing, that's a real risk for the tenant. You would need to know from the tenant in writing that they're okay, that there was no written criteria, and then proceed forward on something like that.
Thank you for that.
Yeah, there's just a huge risk on the tenant side. And any landlord who did not provide the criteria to the prospective applicant and then said you're not approved, I think they're going to reimburse them any of their fees that they pay.
They should reimburse them?
Yes, if they did not provide the rental criteria in writing, because how would that poor applicant know that they met the criteria or not?
Exactly.
Yeah, it just doesn't seem fair at all.
Isn't that my fault then?
No, no. It would be your best practice to always put that in writing once you know that, so that the tenant can tell you, I'm okay with this. And then they're the reason they went forward, not without knowing that.
Exactly. I will do that next time. Thank you.
You're welcome.
But Marilyn, the risk part, hi, by the way, the risk part is the fees and everything that they're putting into the application, correct?
Mm-hmm.
Okay.
Mm-hmm. Bye.
Thank you, Marilyn. Marilyn, sorry, one last question.
Okay.
On the buyer's.
I'm sorry. You cut out.
Can you hear me?
Yes, ma'am.
Yeah, buyer's rep agreement 11F. How much was that number?
What?
In the buyer's rep agreement, paragraph 11F, construction, the commission for construction is whatever you want to put, or is there like a number that you suggest? No.
You can put with his normal compensation through MLS, something like that.
Thank you.
Yeah.
Bye,
Bye.
Marilyn, thank you.
That's
Marilyn,
okay. Take care, everybody.
Marilyn, can I have a quick question?
Okay.
Can I ask? I saw one time in a tax record where it says the year built of a home is 1979, but the effective year built is 1987 or 86. Does that mean the building was not complete until that day? It was like 7 years difference.
Somebody would have to do some splaining on that because that does
Yes.
not make sense to me at all.
I know, that's why I was like, what? What does that mean? The year built is 1979. And the effective year built, it was on the bottom of that sheet, the tax form. It says 1986.
Your buyer
or
would
86.
need a real explanation of that before they went forward.
Mhm.
Yeah.
Okay, thank you very much.
Okie dokie. Bye.